my God, sir. The petition is
Any mention?
I think there's too much of outside noise in your connect. Yes.
Supplementary list item number 1.
This song called technician. Cut it out first. Any mention, Mr. Ghosh?
Item 1 on the daily list.
Okay, then you just get a lot of background noise coming from their end.
Supplementary list item number 1.
Where's the councillor? Where Dr. Mozika?
Lordship, he's in court 1, Lordship.
Where's the counsel for the petitioner? Who's the counsel here? Huh? Oh, no. And that's good. What to do? Yes, none appears for the petitioner. Let the matter stand up to next week, yes.
2.
2 also, same lawyer, same order.
Daily list item number 1.
My lord, senior advocate.
Yes, but I think your submissions are over, correct?
No, my lord, this is not the.
No, my lord, this is
that's other matter.
Oh,
This is the Argus matter.
sorry, yes.
yes. They are yet to file their counter. It's been almost 2 months.
I'm praying for some time.
Yes, Dr. Mozika, what is the
For
problem?
some more time. No instructions have come in.
No instructions have come. What to do, Mr. Ghosh? We'll have to allow some more time. Necessary. Yes, Dr. N. Mozika.
Well, I'm praying for a little longer time, well, maybe 4
4
weeks
weeks time.
4 weeks time.
Praise for the week's time to file affidavit. Prayers allowed. Yes, the matter on so interim order should continue until the next date. Yes.
I'm so obliged, my lord.
Obliged, my lord.
Item number 2.
Lordship, please. Lord, in this matter, rejoinder has been filed around 6:30 or something, with some documents
In the
have been in the evening. In the evening, 7:30.
Last evening, we had some challenges to take care because the gentleman who was affirming the affidavit was not well. He was in the hospital, so we had to get the infrastructure there. So it took some time, but we served it. We filed it today. I think it must be available in the Lordship's record. Would Lordship take it end of the board if it is not
Lordship may have
inconvenient?
it tomorrow. I will ask.
Tomorrow?
Tomorrow.
Can it be end of the board then?
No, our bench will be there tomorrow.
Can it be end of the board?
Because
if
there
it
are
is-
2 matters in the DB1 also. There are 2 matters in DB1 also.
Regarding this same.
No, the other matters, other cases are there. So today some difficulty, and I have to go. I have to take
So you just
instruction.
you arrange with.
Take instruction also. My lord.
End of the board,
Yeah, fine.
it will be.
It is reported by Mr. Open that rejoinder has been filed.
Yes, ma'am. It's been filed today morning.
However, the same is not yet on board. So accordingly, the matter stand over to next week after the Diwali. Yes.
Any date your Lordship will indicate if it is not.
Can you take a date, Mukul Master? You
Aye.
fix it with the Appellate General.
Actually,
We are here every day. I mean, we are here on Tuesdays and
उससे पहले कर लेंगे।
Thursdays. Yes.
Hearing item number 3.
Affidavit saying that they would now comply with the order of this court on the interim order. This is that miscase where they had debited the tax even though there was an interim order in place.
Miscase can be
They are
disposed.
seeking a direction of this court to comply with the order.
So how should he seek direction of the court?
Para 4.
Is either you comply, don't comply.
My lord, we have the intention of complying. My lord, if in case
Intention or
We kindly see para 4.
decision has been taken by the government. Has it been taken by you all?
My lord, I had the instruction to file the affidavit, my lord, we have filed.
Where's the affidavit? But we have instructions too.
Well, they admit that they have made a mistake and now they ask for an order of this court so that they can rectify. That is quite strange. Para 4.
Where's the affidavit? Yes. Yes. An affidavit has been filed by the state respondents indicating that what are you written here? The amount is recovered inadvertently, and the same was unintentional on the part of the respondent. A statement has been made in para 4 of the affidavit, which is reproduced here and below. You quote para 4 or affidavit stop. In view of the averance made in the affidavit, how much time? Give you 1 week's time. Yes, the respondents to revert the amount to the applicant within a period of 1 week the date of receipt of this order. Yes, in this case, the stands disposed of. Yes. Now the next one.
In the main matter, unless my learned friend has any submissions, let me reserve it.
Who has submissions? We have for the submissions, right? How long will it take?
My lord, 30 minutes, my lord.
30 minutes.
Yes.
Now it's what time to have any other matters?
Yes, sir. It is.
Okay then. Yes, you start.
Very well.
What, Mr. Ghosh, have you given your notes on submissions?
Well, we are preparing it.
Because the thing is that to traverse your compilations will be a Herculean task.
No, absolutely. So we have already I've got the draft in my office from my juniors. I'll have it submitted as soon as my learned friends give this. I'll submit it. And if I have anything additional to add in counter to what my learned friend says, I will take some time. That's all.
Yes, yes.
Look, in between, excuse me, I may have to rush to another port.
Yes, yes. You're juniors. You're not supposed to be replies today. So
yes. I'm so obliged, brother. Oh, your phone.
My lord, as far as the contention of the petitioner, my lord, their contention is that, my lord, the show cause which was issued by the additional director, my lord, DGGI, he is not the proper officer in terms of section 291 of the CGST Act, and therefore the show cause which was given by the said officer is invalid. And the second contention is that the adjudication order, my lord, which was passed by the additional commissioner CGST, he is also not the proper officer in terms of section 291, and hence the order is not correct. It is invalid order, my lord. Now, as far as this contention is concerned, our submission is that, my lord.
First, you're addressing proper officer.
Proper officer, my lord. That is my first, because that is the.
You think it's the crux of the matter?
Right, my lord. That is, if they do not have the power, my lord, there is no question of going ahead with the adjudication, my lord. Now here, as far as this provision of section 291 is concerned, if my lord has a copy of the
1 second. Yes. Just getting there. You're referring to section?
Yes, section 291 of the CGST Act, my lord.
1 second. Like this. No. There is.
2 bracket 91, my lord.
2 bracket 91.
Yes, my lord.
Yes.
It's a section that is connected to definition, my lord.
Proper officer.
Yes. Now, proper officer in terms of section 291 is that proper officer in relation to any function to be performed under this act means the commissioner or the officer of the central tax who is assigned that function by the commissioner in the board. Now here, section 291, it is a definition clause, my lord. This is not an enabling provision. Now, what is the enabling provision? That is section 3 and section 5 of the act. If my lord will see section 3.
The question also, who can enable them?
Yes, that
Whether
is
they've been,
right.
whether they are competently enabled.
Right.
Even if you say that it's just a definitive section.
Yes.
Yes.
Now section 3, my lord, if my lord will see section 3, it states officers under this act. The government shall by notification appoint the following classes of officers for the purpose of this act, namely so and so, these are the officers. Now by exercising power under section 3, the government can make appointment of these officers for the purpose of this act, my lord. And if my lord will see section 3, then clause I, it says any other class of officers as it may deem fit. Even the central government, my lord, has the power to appoint any other officers for the purpose of this act, my lord, to do whatever necessary under the provision of this act. Now section 5, it says powers of officers. It says subject to such conditions and limitations as the board may impose. An officer of central tax may exercise the powers and discharge the duties conferred or imposed on him under this act. Now it is not saying who will exercise this power. As far as limitations and condition is concerned, the board may impose some limitations and conditions. However, it does not say that the power has to be invested by the board. It says subject to such conditions and limitations as the
Just come again there.
Yes.
Subject to conditions limitations as the board may impose.
Yes.
Is that the government?
Board, yes, board conditions, limitations that can be imposed by the board. What that is saying, but it is not saying who is invested with the power to.
Who's the investing authority? You
Yes,
say has not been defined.
No.
That's your case.
No, my lord may see this. It says subject to such conditions and limitations as the board may impose.
Yeah.
An officer of central tax may exercise the powers and discharge the duties conferred or imposed on him under this act. Now, who will impose? There is no mention about it. Now, my lord, may kindly see subsection 2, clause section 5. It says, an officer of central tax may exercise the powers and discharge the duties conferred or imposed under this act on any other officer of central tax who is subordinate to him. Even here, my lord, there is no mention. Now, however, my lord, this chapter 2, this relates to administration. Now, section 3 empowers the central government to appoint the officers. And this is section 5 also, it is continuation of the same chapter as administration. Now, when the central government has the power to appoint, it also has the power to invest them with the power. Now, if my lord will see my compilation, page number 96. Now, my lord, as far as show cause notice was concerned, my lord, it was issued by the additional director Director General of Goods and Service Tax Intelligence. Now, if my lord see this, my lord will see this notification number 14 of 2017, dated 1st July 2017, my lord. It says, in exercise of powers conferred under Section 3, read with Section 5 of the Central Goods and Service Tax Act 2017 and Section 3 of the Integrated So-and-so, the Central Board of Excise and Custom hereby appoint the officers in the Directorate General of Goods and Service Tax Intelligence, Directorate General of Goods and Service Tax, and Directorate General of Audit as specified in column 2 of the table below as Central Tax Officers, and invested them with all the powers under the Central Goods and Service Tax Act. Now here, serial number 4, my lord, it says Additional Director General Goods and Service Tax Intelligence, and the second column, my lord, officers whose powers are to be exercised, power of the Commissioner. Now if my lord will see the next page, page number 97, it says serial number 8, Senior Intelligence Officer, Goods and Service Tax Intelligence. He is exercising the power of the Superintendent. Now, as per Section 291, my lord, it says who is a proper officer. Proper officer in relation to any function to be performed under this act means the Commissioner. Now here, Additional Director DGGI, my lord, has been entrusted with the power of the Commissioner.
See, the thing is that you interpret Section 3 again.
Yes.
Now the government shall notification appoint class officers.
Yes.
Now this notification 14/2017 says the central board.
Yes. Now, my lord,
that you just
already I have argued, my lord. This CBIC, my lord, it is not. It is just a wing of the.
whatever,
wing
but
for
then the arguments for the other side is that it is incompetent.
No, in my argument, in my understanding, my lord, he is competent because they are ultimately, even the board is exercising the power
Or central government.
of the central government, my lord, under which I have already argued in the earlier submissions, my lord. Now, as far as the Commissioner, my lord, power is there, this has been invested with the Additional Director in terms of this Additional Director DGGI, my lord. And once he has been invested with the power of the Commissioner, he is already the proper officer, because proper officer in terms of Section 291 is the Commissioner. Now, Additional Director has been invested with the power of the Commissioner, so he ultimately became the proper officer, my lord. Now, again,
something to support your contention that the Central Board of Excise and Customs is the action amounts to an order of the Central Board, so amounts an order of the government itself.
Ultimately, my lord, they are discharging.
Question of being answerable to the central government, not, but whether they invested with their power. Because the Act said very clearly, the central government shall, these are task officers that will be appointed. Correct?
Yes, appointed under Section 3.
Yes. Under
Now,
Section 3, the government shall by notification
yes,
appoint the following class officers for the purpose of this Act. For the purposes of this Act. Now, all of them, like you say, number 4. Number 4 also is at E. Additional commissioners.
yes,
Additional directors.
right.
So on.
No, my lord. Here these are
will be covered by E.
Additional Commissioner of Central Tax, my lord. Here.
Yes.
Now, who was appointed here, my lord? Additional Director General, my lord. DGGI.
E also additional directors.
Yes.
Of central tax. Then
E is Additional Commissioner of Central Tax, my lord. If my lord will see. Now, who was appointed here, my lord? Additional Director General, Goods and Service Tax Intelligence. Now, he was appointed as the proper officer, my lord, and he was entrusted with the power of the Commissioner. Now, as soon as he was entrusted with the power of the Commissioner, my lord, in terms of Section 291, he becomes the proper officer, and moreover, my lord, he is entitled to issue the show cause, my lord. Now, as far as the adjudication order is concerned, my lord, adjudication order was passed by the additional Commissioner CGST. Now, in terms of notification number 2 of 2017, if my lord will see page number 70 of my compilation, my lord.
Page 70.
70, my lord, yes.
away from the road, the person back to the objection. So they have like that means restriction. That means like they can do your remedy and come straight back to the objection. That's also very crucial. So we come in here and it's not even a exercise which is inherent. That is right. So far as yes, that's why otherwise can be taken up. But hidden now, if wrongful exercise, yes.
Yes. Now, my lord, if my lord will see page number 70 of my compilation.
Yes.
Now, this is the notification, my lord, by which Additional Commissioner of Central Tax, he has been appointed as a Central Tax Officer.
1 second. Yes. You are referring to page 70.
Page 70, my lord.
This notification number 2.
Notification number 2, 2017.
Yes.
Now, by this notification, my lord,
Yes.
the Additional Commissioner of Central Tax, my lord, if my lord will see paragraph subclause E, Additional Commissioner of Central Tax, he has been appointed as a Central Tax Officer and vest them with all powers and both powers under both the said acts and the rules made thereunder. Now, after this notification, my lord, this notification was amended, white notification number 2 of 2022, that is at page number 94. Now, this additional commissioner is the person, my lord, who has passed the order, adjudication order, my lord. Now, as per the petitioner, he is not the proper officer, my lord.
So,
Page 95.
this amendment was made central government to the notification made by the board. Is that your case?
Right. No, my lord, can you see here what they have done? Page number 94.
See, Mr. Sinkan.
Yes.
The central government hereby makes the following amendments in the notification of the Government of India.
Yes.
What this notification 2 says? Board of Excise. How do you reconcile that?
It says, my lord, the central government hereby makes the following amendment in the notifications of the Government of India in the Ministry of Finance, Department of Revenue number 2, 2017. That
You're talking about the same 70, correct?
2
Are you talking about
2017.
notification in page 70?
Page 70, same notification that has been amended by way of this notification, my lord. That is page number 94.
Correct.
Yes.
But this page 70 notification, it was issued by the central board.
My lord, there was correction that was made, and instead of
Even the correction that was made,
It-
that mean instead of central board, it should be
central government, it was
That's your case.
it was already corrected, my lord. That correction was done, corrected to corrigendum dated 29 July 2019.
Come again, yes. Because let us understand, this is crux of the matter.
Yes, my lord.
Yes.
Page number 70, the notification, my lord, where the Central Board of Excise and Custom is mentioned. In that place, my lord, the government has
Where's the
been,
corrigendum?
my lord, this is there already part of the writ petitions. That is at page number 176 of the writ petition, my lord.
Okay. Corrigendum to
Dated
notification
29 July 2019, my lord.
17 dated.
29 July 2019.
So now you say that's because of corrigendum and subsequent amendment, so everything becomes in order.
It is not the case, my lord. My case is, my lord, the government has the power.
No. Your case is that notwithstanding, even though the government or the board is set as one,
Yes.
now this amendment has come, corrigendum has come to the notification at 217,
Yes.
an amendment subsequently by the sub 2 of 2022. So now everything is streamlined.
Yeah, in my,
That's your case.
yes, not because of the amendment, my lord, but because, my lord, the power was invested, that is my case, by the central government. And here, my lord, will see page number 94.
Yes.
Page number 94, my lord, it says, the central government hereby makes the following amendment in the notifications of the Government of India in the Ministry of Finance number 2, 2017, that notification, my lord, dated 19 June 2017, published in so and so, so and so. Now, in the said notifications, after paragraph 3, the following paragraph shall be inserted, namely 3A. It reads, my lord, notwithstanding anything contained in paragraph 3, the additional commissioner or the joint commissioner of central tracts, as the case may be, subordinate to the principal commissioner of central tracts or the commissioner of central tracts as specified in column 2 of the table 5, are hereby vested with the powers as specified in the corresponding entry in column 3 of the said table. Now if my lord will see the table, it says power of additional commissioner or joint commissioner of central tax for passing an order or decision in respect of notices issued by the officers of Director General of Goods and Service Tax Intelligence. In this case, notice was issued by officers of DGGI, and therefore this notification was brought in, my lord, wherein the power was vested with the additional commissioner or the joint commissioner of central tax, my lord, for passing an order or decision in respect of notices issued by the officers of Director General of Goods and Service Tax Intelligence. Now if my lord will see the column 3, it says power. What power he will exercise? Additional commissioner. It says power exercisable throughout the territory of India, passing an order or decision in respect of notices issued by the officers of Director General of Goods and Service Tax Intelligence under section 67. Next page, my lord.
Yes,
73, 74, 76, all these sections, my lord, of Central Goods and Service Tax Act 2017. This case is under section 74, my lord, whereby here, my lord, by this notification, the power was invested with the additional commissioner to take decision, my lord, and accordingly decision was taken, my lord, which is under challenge in this repetition, my lord. And therefore, my lord,
you mean whatever irregularity was there has been straightened out, the correct officer issued to show cause, and educating authority, the correct authority, the proper officer that has passed
yes. In my humble submission, he is the proper officer.
Okay.
And my lord, this is not a new issue, my lord. This has already been settled, my lord, by the Honorable Allahabad High Court, my lord. The paragraph 20 of that said judgment is very relevant, which I would like to point out, my lord.
Where is that?
That is page number 182 of my compilation, my lord. And relevant paragraph is 46, relevant page is 235, my lord. My lord, that is wrong. 197, my lord, relevant page. The actual paragraph starts from 196, paragraph 20. It says, my lord, starting from page 196, my lord, relevant, 2 line in.
One second. You read para 18 first.
Yes.
Read page 196, the last one. Further section 3 of Central Board of Revenue Act. Just read that part.
Yes.
Page 196.
Further section
line.
3 of the Central Board of Revenue Act 1963 relating to constitution of Central Board for Indirect Tax and Customs says that it is the central government which shall constitute the Central Board of Indirect Taxes and Customs, and the said board shall be subject to the control of the central government and shall exercise such powers and perform such duties as may be entrusted to that board by the central government or
Subservient. Yes.
or by or under any law. Thus it appears that the board is subservient to the government under this act. It could be well argued that when the power has been invested with the board to do certain things, how can the government not exercise power? That is one point, my lord. Now if my lord will see paragraph 20,
Yes.
it says a conjoint reading of notification number 14 of 2017 dated so and so and circular number so and so sufficiently contemplates the assigning of powers to DGI officers by the board. Let's take an example. As per circular number so and so, a superintendent of central tax has been assigned the power to function as is mentioned in subsection 1 of section 70 and a reading of notification number so and so leads us to conclude, as mentioned in serial number 8, that a senior intelligence officer, goods and service tax intelligence, or superintendent, goods or service tax, or superintendent audit has been notified to be appointed under section 3 of GST Act as a central tax officer and is invested with all the powers under the Central Goods and Service Tax Act 2017 throughout the territory of India, as are exercisable by the central tax officers of the rank of superintendent. In any case, this court does not find any force in holding that such technical nuance to be fatal for the notifications or to the functions performed by various DGGI officers. The jurisprudence on the implications of invocations of a wrong provision suggests that as long as an authority has power which is traceable to a source, the mere fact that source of power is not indicated or wrongly indicated in an instrument does not render the instrument invalid. Now here the source of power is there under the Act. The moment you can appoint somebody to discharge duties under the Act, the government also has the power to invest him with proper power, my lord, and duties, because the power to appoint is there is no denial in that aspect. And this is also the case by the Honorable Supreme Court, wherein Honorable Supreme Court also, my lord, at page number 235 of my compilation, my lord, same way even it was held that it is a trite law that as long as an authority has power which is traceable to a source, the mere fact that the
Which
source of
reading? 235.
235, my lord, that is page, paragraph 46. This is
Okay, yes.
this is a judgment of the Honorable Supreme Court, my lord. Here it says 235, my lord, page number. It says it is a trite law that as long as an authority has power which is traceable to a source, the mere fact that the source of power is not indicated in an instrument does not render the instrument invalid. Therefore, my lord, it does not matter as long as the power is there under the Act. It does not matter whether the notices has been issued by A or B. Only on that hyper-technical ground, my lord, it cannot be said that the entire proceeding which has been taken up, my lord, that has been...
It's without jurisdiction.
Yes, my lord, without any jurisdiction. And moreover, my lord, here it is never a case of the petitioner, my lord, that they have not been provided with a show cause notice, or they have been prejudiced by any way. They have been given a proper show cause notice. They have got an opportunity to reply. Natural justice was followed, my lord, and therefore they are no way aggrieved whether the order is signed by A or B, as long as the source of power is there under the Act, my lord. That is my submission. Now,
That's it for some other submission.
as far as proper officer is concerned, my lord, other submissions are there. Now, the petitioner, my lord, they have heavily relied on section 142, subsection 11, clause B.
1 second. Which
Yes.
B.
My lord, as far as state is concerned, we are relying on section 142 clause 10,
10.
whereas they are relying on section 142 clause 11b. Now, I'll read the provision, my lord. Section 142 clause 10 says, save as otherwise provided in this chapter, the goods or services or both supplied on or after the appointed day in pursuance of a contract entered into prior to that appointed day shall be liable to tax under the provision of this Act. This is my contention.
They said that their contract got over 2014.
Right. Prior to 2014?
When is the date? I mean, the date of incidence, that's the thing.
Yes, as per their contention, my lord.
I mean, the
Yes,
event.
but
Yes.
this provision says, my lord, even though you have entered into a contract prior to the appointed date, that is 1st July 2017, when the GST came into
Came to
picture.
call, yes.
Now, even if you have entered into a contract prior to that date, my lord, even then you are liable to tax as per subclause as per clause 10, my lord. It says, save as otherwise provided in this chapter, the goods or services are both supplied on or after appointed day in pursuance of a contract entered into prior to the appointed day shall be liable to tax under the provision of this act. Now, the petitioner has relied upon section 142 clause 11b. It says, my lord, 11a it says, b says, notwithstanding anything contained in section 13, no tax shall be payable on service under this act to the extent the tax was leviable on the said service under chapter 5 of the Finance Act 1994.
See, if we understand correctly, the argument was that all these services, goods that was provided was went under the Finance Act before the advent of the GST. Correct?
Yeah, our case is different, my lord.
And your case is different. You're saying that notwithstanding, even if it's a continuing process, that means taxable events continue.
Yes, and moreover, I'll give an example. I have given one so that it will be easy for us to understand, my lord. I have given one example how it has to be. This provision has to be read, my lord.
What example is this?
Now, if my lord will see,
okay, just continue.
My lord will see the next page exactly on 142.11 only. Next, the page number. The one I have given, my lord, it says
this document.
Yes, this document, my lord, may kindly see section 142.11 CGST Act, GST transition rules for VAT and service tax transition and credit claim explained.
Yes.
Section 142.11 of the CGST Act 2017 outlines transitional provisions for transactions taxed under the previous VAT or service tax regime. It specifies that GST will not be levied on goods or services to the extent they were taxed under the old laws. Now, what this chapter 5 of Finance Act is, my lord? Chapter 5 of Finance Act relates to service tax, my lord. That my lord is aware. Now here it says, for supplies taxed under both VAT and service tax, GST is applicable, but the taxpayer can claim credit for taxes paid under the prior regime. This section addresses scenario like advance payments and work contract, ensuring that GST is only applied to the portions of transactions not previously taxed. My lord, may kindly see the next paragraph. It says section 142.11, notwithstanding anything contained in section 12, that is A, and if we see the B, notwithstanding anything contained in section 13, no tax shall be payable on service under this act to the extent the tax was leviable on the said services under chapter 5 of the Finance Act 1994. My lord will see the next paragraph. Accordingly, this section can be divided into three parts as are.
Where have we taken it out from? This is just
illustration. Yeah, illustration, my lord. I will so only for the purpose of understanding, my lord. It says VAT. When VAT is levied in relation to supply under VAT, then GST will not be levied. Point of taxation for VAT is sale of goods. Therefore, if sale of goods made as well as invoices raised on or before appointed day, then GST will not be levied on the supply to the extent tax was levied under the VAT. Service tax, chapter 5 of Finance Act, which relates to, my lord. It says, when service tax is levied in relation to the supply, then GST will not be levied. Points of taxation for service tax is the date of invoice or the date of completion of service or payment, whichever is earlier. Therefore, if invoice is raised or payment received on or before appointed date, then GST will not be levied on the supply to the extent tax was levied under service tax. Example.
So in this case, will you take it a date of completion or date of payment?
Date of invoice, my lord.
Invoice means date of payment.
Yes, date of payment.
That means date of completion of the project will, according to you, will not be important.
Yes, my lord may see the example here. This is exactly on the point. Example, 1 lakh was received on 28th June 2017 for service to be rendered in July 2017 when the GST came into picture, my lord. The invoice for the service was raised for 1,50,000 on 31st July 2017. Appointed day as 1st July 2017. GST shall be levied only on 50,000. Advance was prior to GST, and therefore on 1 lakh there is no GST. Only on the payment 50,000.
29 June.
Yes.
And for the other
GST
amount
is
received on 1st July, then that 50,000 will be levied.
GST is leviable. Now, even the Even the next point, VAT and service tax. In cases where VAT and service tax both have been paid in relation to supply which is to be made after appointed date, then a registered person can claim the credit of taxes paid under existing taxation regime in GST regime. It may be noted that GST is to be paid on full value of supply, although tax paid under existing taxation can be claimed as credit. In short, person will have to pay different tax amount to the government. In case of work contract service, here our case, yes. In case of work contract service, construction service and food and beverage services, etc., VAT and service tax both are levied. In this case, if a person has paid any tax under existing taxation in respect to the supply to be made after appointed date, then the person will have to pay full GST under GST regime, and such person can claim the credit of tax paid, VAT and service tax. Example, contract entered in March 2017 for 1 crore, advance received till 31st June 2017 amounts to 10 lakhs VAT and VAT of 40,000, service tax 60,000 have been paid on the said advance. Appointed day is 1st July 2007. GST shall be levied on 1 crore as per section 13 of the CGST Act. VAT and service tax paid 1 lakh total shall be allowed as credit under whatever they paid them, that will be as a input tax credit. My lord. Yes. This is as regard to section 142 subclause 11 who is there.
Take this illustration out.
My lord, this is from my lord online only I got it, but
you just found it recently.
Yes, my lord. Just found it recently.
Yes. What about section 13? Anything else?
Section 13, my lord.
Because they had addressed section 13.
Right. Now, my lord, section 13, time of supply. The liability to pay tax on services shall arise at the time of supply as determined in accordance with the provisions of this Act. The time of supply of service shall be the earliest of the following dates: the date of issue of invoice by the supplier, if the invoice is issued within the period prescribed under so and so, or the date of receipt of payment, whichever is earlier, either the date of raising the invoice or the date of receipt of the payment. In both the cases, it has been done after GST came into picture, after 2017, my lord.
Both invoice and payment.
Both, my lord, after invoice is raised, the payment will be made. So, now, the petitioner, my lord, has also referred to Schedule 2. Schedule 2, my lord, of the Act. If my lord will come to Schedule 2.
It's 127, 126. Yes. Yes.
Yes, my lord, this Schedule 2, it relates to activities or transaction to be treated as supply or goods or supply or of services. Now, they have relied upon Schedule number 5, supply of services, clause B. There is an exception on which, my lord, the petitioner is relying upon. Now, it says supply of services, the following shall be treated as supply of services, namely, B. Construction of a complex building, civil structure or part thereof, including a complex or building intended for sale to a buyer, wholly or partly, except where the entire consideration has been received after issuance of completion certificate, where required by the competent authority or after its first occupations, whichever is early. Now, they are relying upon this exclusion clause where it says except where the entire consideration has been received after issuance of completion certificate. If they come under this exclusion, it will not be treated as services. That is their condition. That is their contention, my lord. They said they falls under this exception because they have received the payment after completion of the work, which is not true, my lord. The contract concession agreement is for a period of 20 years, and it is one contract for different supplies, supply of services.
So you abandon that's a construction contract. It is not for construction, that means.
I am coming on to that, my lord.
Yes.
I am saying, what I am saying is it is a composite supply. It may include construction, it will include repair, it will include maintenance, operation, everything. And for this, so many supplies, my lord, there is only one contract which has been signed, that is the concession agreement. That is for a period of 20 years, which will end in 2031. His entire period, he is bound till 2031, my lord, after which his contract will be over. He cannot say only one part of the work is completed, that is the construction, which is the main part, which is the principal supply. Whereas all other ancillary supplies, that will continue, repair, maintenance, operation, that will continue up till 2031. But the petitioner's contention is that the work is already completed prior to 2014, hence they are not liable to pay any GST. That is not the case, and moreover, my lord, this serial number 5 clause B, it is not applicable for these kind of projects. This is applicable. Why I am saying, my lord? My lord may kindly see this. It is only related to real estate project where the builder intends to sell those flats after being already made. Now, my lord may see this provision B. It says supply of services. The construction, the following shall be treated as supply of services, namely construction of a complex building, civil structure or part thereof, including a complex or building intended for sale to a buyer. Now here, to sell something to somebody, he must own this property. Here, all these in real estate projects, they own the project which is sold after it is being made. Therefore, this.
But they have argued that notwithstanding anything, they own a project till the date that when the in terms that 1 rupee was the time. So they owned the project entire period of construction, mobilization, operation.
Now that is one, and what they have submitted also, my lord, what is beneath beneath and what is above, that is all land.
No, that
now for
I'm just
that,
recalling.
yes,
I
right,
remember correctly,
right,
that's what he said. That is
now if they have to own, they have to acquire the land, they have to buy the land, my lord. Now without owning, how can he sell the land, my lord? His project, as per the tender, my lord, if my lord will go through the tender paper which is there in the writ petition also, it was for construction and maintenance and all other. This is a composite supply which he has made, my lord. And composite supply, in this composite supply where he has to supply various kind of services, the construction being the main supply, principal supply, which is not exempted. If principal supply is exempted, then he can definitely say that he is not liable to pay tax. Now when the principal supply is taxable, therefore he cannot say, even suppose ancillary supplies, what Leonard Senior was taking the plea that access to a road or a bridge on payment of annuity, that is exempted. Now that is access to a road or a bridge on the construction is silent there, but his main principal supply here is construction. Suppose for a moment, my lord, we see that we say that the ancillary supply, that is access to a road,
bridge.
Yes, that is suppose exempted. Even then, he will not be able to take shelter of that, because the principal supply, my lord, it is taxable. That is the construction. That is my submission, my lord. And as far as serial number 5B, this is only relates to real estate project, my lord. And he has also relied upon, my lord, schedule 3, that is activities or transactions which shall be treated neither as a supply of goods nor supply of services. And he has taken shelter of serial number 5, sale of land. Serial number 5.
Yes.
He taken shelter of sale of land because he is engaged in sale of land, therefore no tax. Now to sell the land, my lord, there first he has to acquire the land, he has to buy the land, then this provision will come into picture, my lord. So this is too far stretched argument, my lord, which has got no relevance as far as this case is concerned, my lord. Now here, as far as this case is concerned, my lord, petitioner, my lord, he was fully aware about the position of law that he is liable to pay tax. However, he has declared his supply as an exempted supply, knowing fully well about the situations that he is taxable, and therefore, because he has suppressed the facts and he has given misstatement.
Why you say that?
Only to evade tax, because the position of law is this, but they have misinterpreted only to evade the tax. Whereas if my lord will see all the provisions which I have already explained, there is no exemption that is available on them, available to them. He is supplying a composite goods, composite supply. He is making a composite supply, which is a taxable. However, he has declared his entire supply, almost 800 something crore, my lord, as an exempt supply, and therefore he has suppressed the real facts, and therefore, my lord, he is entitled to be proceeded under section 74 of the act, my lord, and accordingly, rightly, my lord, the tax was rightly determined by following the provision under section 74, my lord. That is my submission, because he has made a suppression and he has given a wrong statement, my lord, only to evade, with an intention to only to evade tax, my lord. Now the learned senior has also made the contention that there was no mention of section 142(10). This is the first time I have raised, but if my lord will see in the adjudication order, it is already there. If that is only my last submission, if I can, if my lord will take up the writ petitions copy, my lord. The first volume only, my lord, that is first synopsis.
Yes.
If my lord will come to page number 111.
Is that volume 111? So voluminous has come.
Yes, my lord.
It becomes very difficult to navigate your papers also.
Impossible. Page 111, my
You
lord.
have to give your notes.
My lord, I'll give my written arguments.
But otherwise, if we just cross-referencing,
Yes,
you might get,
I'll file my written arguments.
will get lost.
Yes,
Not anything, but under the paperwork.
yes.
Yes.
111, my lord, page number.
Yes.
If my lord will see first paragraph, the last 4 line, my lord, as per section 142(10), this is the adjudication order, my lord.
Yes.
As per section 142(10) of the CGST Act 2017, the goods or service are both supplied on or after appointed day in pursuance of a contract entered into prior to the appointed day shall be liable to pay tax under the provision of this act. This is very well mentioned in the adjudication order. And also, my lord, paragraph 1.11.
1.9, correct.
Yes, that is paragraph
They have mentioned section 142(10).
142(10). Yes.
Okay.
Then again, in the same page, my lord, paragraph 1.11, same page. The entire taxability, my lord, tax has been determined as a composite supply. Here it says.
Common supply was contract supply.
Yes,
construction,
as per
erection,
section 3.
Commissioning, installation, completion, fitting out, repair, maintenance, renovation, alteration.
All these notifications which has been referred, this relates to composite supply. His tax was determined on the basis of these notifications. Tax rate applicable for a composite supply. That is from the very beginning. That is there in the that paragraph, my lord, may kindly note it.
Para 1.1.
1.11, page number 111. That is all my submission, my lord. Thank you.
Yes. Yes. When can you,
Your Lordship, Your
as a
Lordship,
senior, wish to make
indeed, Your Lordship. Can the matter be listed on 18th of November, Your Lordship? Because there are a couple of points which my learned friend has raised.
See, we are stretching this matter.
Keep
We
on
thought
going,
that
my lord,
today will
in
be the
that way.
last day.
Your Lordship,
Yes.
we'll keep the
Cannot be, my
submissions
lord.
very short since he's already
We have
addressed this on
already argued all the points, my lord.
aspects, but there are two aspects. One is
Well, it's
vis-a-vis
just
the
rejoinder
constitution
arguments. He's just
We
answering to
can
the
add it in
points.
the written
Yes.
submission.
I understand, Your Lordship. We'll keep the submissions very short and we'll also
They
make the written submissions
can
very short.
add it in the written submission.
Or to cut it short, my lord, let it be
Your
written.
Lordship,
My lord,
but
whatever they
two
can say the
aspects
same.
have actually been
We'll say the
Let
same.
them say,
Just a
yes,
just a
yes.
moment. They can say
What is the new things that have been brought up with regard to proper officer
Your
email?
Lordship, regarding that, it was never argued by Mr. Ghosh that whether the power is with the central government or with CBIC. His submission was while Section 3 has the power to appoint, it doesn't give the power to invest. And in fact, my learned friend had made submissions when he was reading the judgment. The judgment specifically says investment. Section 3 primarily doesn't talk about investment at all. It only talks about appointment.
Appointment,
And
yes.
there are a couple of aspects from the Constitution itself, Your Lordship. Also, on one more point, on Section 142(11), the taxability will be vis-a-vis the date of invoice and not the date of completion. Just 2-3 submissions which are additional. He'll complete the submissions on the said date and we'll make the written submissions.
And only one small point, my lord, I want to add.
We'll keep it very
That
short, Your
Jharkhand High
Lordship.
Court judgment, my lord, Jharkhand High Court judgment regarding the resolution plan and all, my lord, that I have argued that which was set aside as per learned senior by the Supreme Court, that may not be relevant in this case. In that case, Forest Department of the state government was a party. Only another department of the government was not a party. So that conclusions was the Supreme Court has arrived at that conclusion because one part of the government, one department was involved in that resolution. But as far as the state, this case is concerned, my lord, state is nowhere involved in the resolution plan. That is my submission.
Your Lordship, if it could be listed on 18th November, we'll make the written submissions and Mr. Ghosh will address the
Okay,
points
yes.
and complete his submissions.
Right. Uh,
18th of November?
Arguments of the State Council are concluded. He prays allowed to file notes and submissions. Prays allowed. I'm sorry, your name? Your name?
Your Lordship, Anshika Agarwal, Advocate
Yes,
Anshika Agarwal.
MS so and so on behalf of the Legislative Council prays that he be permitted to make short submissions on 18 November and to file notes and submission the same day itself.
Yes, yes,
Yes, accordingly.
yes.
Much obliged, Your Lordship.
Obliged.
next year.
Any mention?
May I please, Your Lordship? Lordship, I beg to submit a mention memo, my lord, for filing of an appeal tomorrow. The appeal has already been filed, Lordship.
Appeal regarding?
First appeal, Lordship. What has happened is that before the trial court, the appellant has filed a title suit, Lordship, and ad interim injunction was granted. Then the concerned respondent, filed an appeal before the lower appellate authority, Lordship. And going on through the case, they've already rendered the title suit non-maintainable, Lordship. We are aggrieved by that, Lordship.
This is second appeal against orders, that means.
Lordship will be first appeal, my lord.
Why first appeal?
We have gone on the first appeal, Lordship. Because
the title suit, that means it'll be in FEO, is again before the lower appellate court. Yes, so you file it?
Lordship.
But make the correct nomenclature.
Lordship.
Yes.
Please, Your Lordship. My Lord, I beg to make a mention of item number 16 of the hearing list.
Number?
On behalf of respondent number 3, Your Lordship. Item number 16. As the conducting counsel is on sanction leave, Your Lordship.
What is this? Been signed?
When
Yes,
signed.
Lordship.
No objection?
No objections, Lordship.
Yes, when?
After 2 weeks, Your Lordship.
Okay, yes.
Obliged, my Lord.
Yes, yes.
My lord, I pray, my lord, that item number 25, it may kindly come up after 2 weeks. I have some difficulty to do, my lord.
Which is this one?
Your Lordship, this matter actually is,
The jointer
has
has been
become.
We have
They have filed, Your
we have
Lordship.
filed it, my lord.
Actually,
Let it come up after 2 weeks.
Oh, after Diwali.
My lord.
My Lord, we are yet to receive
Obliged.
the rejoinder affidavit.
Then you kindly
We'll
give
supply.
jointer to him.
We'll supply, my lord.
Okay.
Obliged.
Good day, Lordship.
He's already agreed that next he'll sponsor everything.
Yeah. No, we have already started the process for the
We'll
next
argue
year.
the matter.
No, they will sponsor everything henceforth. Yeah.
Obliged.
Yes, Mr. Sen.
I beg to mention item number 24 of the hearing list, the university matter.
Regarding that Rajbari, oh sorry, not Raj.
Bijni complex.
Bijni complex, yes.
Some personal difficulties, Lordship, can we
my lord,
accommodate?
no objection.
When?
Well, after two weeks.
But then there's a talk of some
Yes, my
settlement.
lord. They are free to come to us, my lord, or write to us, whatever is.
Have you occupied it? No.
No,
It's empty now.
not empty. Some are occupied, some are vacant. So if they really come, my lord, I think he will be short. Only, my lord, there is an interim order, my lord. Continue.
Interim order continues.
Obliged, my lord.
Yes.
Supplementary list item number 1.
Yes. Yes, Mr. Kumar.
My lord, the petitioner is deprived from the benefit of disability lump sum compensation, my lord. So today I am praying for only notice, my lord. Item number 1 and 2 are similar, my lord.
Yes, heard Mr. V. Kumar. That lump sum compensation was
Yes, my lord.
disability was during the course of his service.
Yes, my lord. During the course of service, the medical category has been recorded.
Low medical category or? Yes.
Low medical category. As
What
my lord.
What medical category? What ailment?
Generalized seizure disorder, my lord.
Yes, sir. Mr. V. Kumar, learned counsel, the petitioner issue notice. Ms. Emily Chang, Vice, Dr. M. Mozika are present on behalf of
All the
all the
respondents.
respondents. No forum to call for list after 3 weeks for accurate instruction. Yes. Next order.
Item 1 and 2 similar.
Item 2
Yes.
are similar, my lord.
Item number 3.
Your lordship.
What is this?
May I please, Your Lordship? Your Lordship, this is a petition challenging the appointment of a doctor for the post of Associate Professor in Shillong Medical College. Your Lordship, the challenge is based on two aspects. The first aspect pertains to the ineligibility of the candidate who was finally selected, and the second aspect relates to how the selection procedure was manipulated in order to ensure
Manipulated.
Yes, Your Honor.
You took part in the selection process also.
Yes, Your Honor.
What is why do you say that who's this respondent number 6?
6. Yes, Your Lordship.
Why is not qualified? Where's the adjustment?
Your Lordship, they are not qualified because.
Where's the adjustment?
Sorry, Your Lordship.
Adjustment.
Page 76, my lord, annexure 2.
Advertisement.
What post is this?
Lordship, associate professor in the department of dentistry.
76.
Serial 20 minutes.
There was one vacancy, Your Lordship, and on page 78,
That is where assistant professor. Where is written the?
Your Lordship, in column number 2 on page 77.
Yeah.
It says that this is the eligibility qualifications for associate professor post, and within that, in column 4, the eligibility criteria is there. Your Lordship, there are multiple eligibility criteria. However, for the purpose of the present petition, the ones relevant are at number D and E.
Number D and E. D is basic course medical education technology, complete basic course biomedical research.
Yes, Your Lordship.
Okay, then why you say that the respondent number 6 does not have these qualifications?
Does not have these qualifications, Your Lordship.
Has the selection process been completed?
Yes, Your Lordship. Your Lordship, it was a very strange situation because the appointment of the respondent number 6 had already been made before the official result was declared. So the official result was declared in March 2025, and there was
before. Are you saying before the official date for the results appointment was made?
Yes, Your Lordship.
Where is that?
Because, Your Lordship, in January of 2025, the petitioner came across a list of provisionally selected academic faculty in Shillong Medical College. This is page 89, Your Lordship, Annexure 4. In this, Your Lordship, on serial number 10 is respondent number 6. And it states that she has been appointed as associate professor in the Department of Dental, and she has been the tentative date of joining has been described as 25th January 2025.
Yeah, we have the official results.
The official result is, Your Lordship, at page number 93, Annexure 7.
This is a provisional also.
Yes.
Same as the earlier one. Yes.
Yes, Your Lordship. However, she had already joined in January as per that list, and she was also being disbursed the salary.
Yes.
My lord will require instructions, my lords.
She's already joined.
Yes, Your Lordship, as per that.
Issue notice.
This notice may be issued.
Yes, your name?
A. Singh.
That Mr. A. Singh, the counsel petitioner, issue notice. Mr. K.B. Varsaji is present. We have respondents number
1 to 4. My lord, 1 to 5, my lords.
1 to 5. No further notice required on these respondents. Notice to issue to the respondent number 6 by Richard A.D. within 3 days. List after 2 weeks.
However, my lords, just one small observation. My lord kindly takes a look at the list, which is annexure 7, my lords, page 93. My lord, the petitioner, even in the list, my lord, his name is at the bottom 6, my lord. Status of the election. So petitioner is here, my lord.
Dr. Ahmed Danish.
In serial 6. After Dr. Rupam Prakash, then you have Ahmed Danish, my lord.
Okay. After Rupam Prakash?
Yes, my lord.
Okay. Okay, doesn't matter. Yes, next.
Item number 4.
Yes. Was this for today, Mr. Goswami?
Yes, it is for filing of.
You file your.
Yes, my lord. Yes, my lord.
We have concluded our arguments, Lord.
Yes, Lord.
Then we reserve for judgment.
Yes, my lord.
Reserve for that.
Interim order to continue.
Interim order could be, yes. Okay, hearing comes from reserve judge.
But reserve for the judgment on the reserve for the judgment on the issue of seeking application, seeking to vacate the stay, because that is the only application pending before your lordship. My friend has filed application to vacate the stay, my lord. We have argued that matter. So
On the vacated it's over.
your lordship, the main matter has not been heard on the merit, my lord. So the application is only listed before your
You've
lordship.
already argued maintainability. That issue we could address.
My lord, the issue is with regard, because
It's intertwined. We can't only see
Your
vacation
lordship, my
also
writ
is
will not-
based on the
No,
whether the application is maintainable or not.
My writ will not.
Let us not.
No, if my lord, why I say so? My writ will probably will not fail on other grounds also, because right now he has only prayed in respect of maintainability, in respect of stay application. My friend has moved the application only for vacating this stay. He has argued that only. At the fag end, he
The court made it clear that the whole matter will be
because
decided.
why we are argued jurisdictional, because he is seeking to vacate a stay on the jurisdictional issue, my lord. That is his argument, my lord. And we said that no, the jurisdiction lies with your lordship prima facie. All these 3 points we have pointed out, my lord. So the issue as on today, because we have moved the amendment application also, we have moved all these, my lord, and we have a case, my lord, on merit and as well as in law also. I would not have gone into that, my lord. So therefore, your lordship may consider this aspect. That is my only prayer.
No, Lordship,
Because no, my friend was not at the fag end. He said, initially my friend said, and all along his first day argument, it was only on the application.
Fine, it started with
application,
the order.
and at the end,
And the basic
and
ground
then
was whether the writ petition is maintainable at all.
Yes,
or
my lord.
whether it can be
No,
invoked. Because whether this court lacks inherent, whether it's like
And on that ground he wanted
of the NCLT
Yes,
taking
my
up the matter.
on that ground.
Both advance arguments that
No, on that ground he wanted to get the interim order vacated, because there are two grounds taken by in the interim order. One, that the IBC lacks the jurisdiction. Second, barred by limitation. These were the two grounds which your lordship will find in the order of your lordship, by which interim order was granted, my lord.
But then that was argued.
So far, and my friend confined his argument to vacate the interim order, only confined to, my lord.
This making it very difficult for the court.
Yeah, my lord, we are in difficult position also, your lordship. Kindly see my.
It means we have to pose a matter for just for you to advance your other set of arguments.
Yes, my lord, on that point alone, and other side, he has not filed reply also. There is no rebuttal. There is.
If the AG gives me 2 minutes, I'll just take 2 minutes, Lordships. As regards, he has said that there were two issues. One was jurisdiction, one was limitation. Limitation certainly cannot be an issue which this High Court will decide.
That issue has to be.
That is again an issue that has to go to the appellate tribunal.
It's only on lack, and also it's not a question of wrongful exercise jurisdiction, a question of lack of inherent jurisdiction on the part of entity. That's the only thing.
No, there are three tests your lordship has. It is also case of violation of principle of natural justice.
Suppose we hold that the case is maintainable, then the matter will follow. If we hold that it's not maintainable, of course.
My lord, then in that case, my writ in that case, my writ will be decided without my writ petition. Main matter is being because
the main point is maintainability.
My lord, that
because you have recourse to alternate remedy.
No, I have recourse to alternative remedy, but when there is a jurisdictional bar, my lord, what my submission is that there is a jurisdictional bar. When there is a jurisdictional bar, and your lordship has, it is a case of violation of principle of natural justice also. Your lordship has seen. I have taken all the arguments.
How would you see?
No,
you
principle.
have been given ample opportunity.
No, my lord, hearing. No, my lord, I am sorry. I didn't advance my argument. No, how I say it is violation of. Kindly give me 2 minutes, my lord. How I say that it is a violation of principle of natural justice is, my lord, natural justice has got 3 facets. One, show cause. Second, hearing, and third, regent order. Regent, and your lordship has seen my grounds on Sabhagya, on my grounds on they were not at all addressed, my lord. That regent order is also part of principle of natural justice, my lord.
Then you have recourse.
No, because so therefore, my lord, therefore, with greatest respect, my lord, therefore the lordship has also, because your lordship has let down the test.
See, Mr. Archival,
yes,
one thing you have to be clear is that, look, if you're arguing on lack of inherent jurisdiction in things such matters,
yes,
then we confine that. Not on the other points like Saubhagya or something. That is
because
the point.
why I say that there is a lack of.
So whether your only argument is that whether in such a situation,
yes, ma'am,
like the dispute is arisen between you and the respondent,
yes, ma'am,
whether the NCLT was right in taking the matter and sending it to the IRC.
Yes.
The resolution preference. That's all.
No, my case. Sorry, I couldn't put my.
Now
case
they
correctly.
have advanced.
My case is,
arguments are that look, it's a government company and it comes to the definition section 3. So all those things they have placed. So let the court. Let the court
the only 2 minutes, my lord. Your lordship, the government companies, the NHI and other companies, all are government companies, my lord. The question, in my humble submission, is, my lord, that government companies discharging sovereign function will come under the code of IBC or not. That is, if it doesn't come, your lordship will have the jurisdiction. That is one. The second aspect is, if there is a violation of principle of natural justice, your lordship surely can exercise 226. Third, if exceptional case is made out, your lordship will certainly exercise. Even in the case the IBC has jurisdiction. This is my alternative argument, my lord. If IBC has jurisdiction, your lordship will exercise. So my writ remedy will not go away because the respondent has filed the application to vacate the stay, my lord. That is, and my entire pleadings, everything is there. That is why my prayer is, my lord, and it is a case of exceptional circumstances. It is a case of exceptional circumstances. That is why your lordship that is why at the beginning only I said, your lordship, let the pleading be exchanged and matter be heard next week also on main matter. On every aspect, because I have to satisfy your lordship that this is a gross violation of principle of natural justice. Hearing is not sufficient, my lord. Hearing is not adequate. PNG is one of the vital part is even reasoned order. My lord, I have authorities to support this part. And if there is a violation of principle of natural justice, your lordship will surely look into the matter. That is my prayer. And that is the state of affair in which I am in, my lord, because he is what says that this amount is due, government saying don't pay the amount, therefore IBC code is invoked, and the NCLT says.
So we understand your case. Your case also, you're saying they're just implementing agency. You're not the what they call it, the basic.
Yes, my lord.
Under a central scheme, we'll examine that.
And that to that extent, my lord, I was saying that it is only confined to 3 tests: balance of convenience, prima facie case, irreparable loss, and I meet all these 3 tests. And my friend's application is only to vacate this stay, my lord. Only to vacate this stay.
Okay, we'll see.
Yes, I'm grateful, my lord.
Lordship, if Lordship will see my vacating application, it is to vacate and dismiss the writ petition. This is the prayer in the vacating application.
Okay, Mr. Gosai, it's okay.
And my lord,
get over it and see.
My lord, only one last submission, my lord. Last submission, one line, my lord, only one line. If your lordship feels that alternative, this is my without. Your lordship may protect me for 2 weeks or 3 weeks. I can. That is, if your lordship feels that because this exceptional circumstances case is there, my lord.
We'll examine it.
It's maintainable. That I am.
Get directly through indirect.
No, these all judgments, even embassy is in my favor. Embassy judgment is also in my favor. I am grateful.
Thank you.
My prayer is reserved only in respect of application, because I have argued application only. My prayer is this much only. I beseech your lordship that only application, your lordship.
See, if the decision in this case renders the entire.
If interim order is your lordship, if interim application is entertained, because my interim order.
Everything hinges on your.
No, because my lord, your lordship, one more now, because what writ is maintainable, question is of entertainability. Writ is maintainable, question is of entertainability, and in entertainability, your lordship has seen there are number of parameters. So it's not a case of complete lack of jurisdiction of this honorable court to entertain my writ petition. My writ is maintainable, my lord.
You will examine it.
Yes, ma'am. I'm grateful.
I've not made up my mind.
Nobody is. I'm so grateful.
Yes.
Please.
Who's appearing this matter?
Sorry, item number 5.
Who's D.F. Mori? MS Bank, yes.
My lord, this matter was sent for mediation. Settled, my lord.
Yes.
And for the state respondents, my lord.
Daily, this item number 1.
Wait, please, Your Lordship. Your Lordship, the conducting counsel is not keeping well. As such, we are seeking for accommodation.
Your affidavit.
No, Lordship. This matter was listed for admission hearing, Lordship. We're challenging the maintainability.
Who's the conducting counsel?
S. Lamba. S. Lamba from Delhi.
Okay, yes. As the RI counsel is available just after 3 weeks.
Item number 2.
RI counsel on behalf of the petitioner. Record the name of the petitioner.
Well, mediations fail, my lord. So let it be posted for hearing, my lord. Pleadings are exchanged, my lord.
The office indicates that mediation has not been successful. Apparently, it's a matter for hearing.
My lord.
For 2 weeks. Yes.
Apply, your lordship.
Item number 3.
Your lordship, the witness has come today. Can you have this matter on the board?
Yes.
The witness has come today.
Which witness is there today?
Tanushri.
The last one.
Last one.
Item number 4.
This matter was for taking instruction, my lord.
Where is the petitioner?
Yes, lordships. In terms of your lordship's last order, my lord, lordship has inquired, put 2 queries, my lord. So far as there were 2 categories of tender, my lord. First category had 2 bidders, my lord. So 1 bidder was awarded the contract. Second category, my lord, second to 10 category, was only 1 bidder, my lord. Out of 1 bidder, he was awarded bids on rate contract basis for essential items only. For non-essential items, retendering. And for category 11, there was no bidder, my lord.
My lord, if that could come in way of some document, my lord, would have given us.
Given you what?
My lord,
given you a document showing that how the matter was
nothing has been provided to us.
The last order records that.
Yes.
Yes. It is there with my friend also.
Copies of our contract being given to you.
It is there with my friend.
Can we have this tomorrow or day after, my lord? Tomorrow or day after, I'll just examine because I have not been able to go through this document, my lord.
Why?
I was a little unaware that this document has already been supplied to us.
See, you understand the submissions have been that. Number 1 with 2 bidders is been settled by bidding process. Category number 2 for essential medicines.
2 to 10, my lord.
2 to 10 as per rate contract because it's essential. And number 3 no bidders. And for those items where not rate contract will be retendered and 3 will be retendered again. Because we can't stop the supply of the medicine because it goes to all the health centers throughout the state. So there's no question of any disruption.
I agree, my lord. My lord, kindly have this tomorrow, my lord. I'll just go through.
Not tomorrow.
After 2 weeks, my lord.
Your senior will always be busy tomorrow also. Yes, on the premise as Thapa, this matter for 1 week. Yes.
Item number 5.
You joined a file, Mr. Sheikh.
Lordship, I pray for another 2 weeks time, Lordship.
2 weeks for the time as prayed allowed to join the. Yes, thereafter also.
Item number 6.
Please, Lordship, the respondent have not filed the affidavit.
No, my lord, we could not settle this matter. So,
no, settle the matter because they on the 2 occasions their officer didn't turn up. Our client have come.
Is a pension matter?
No, my lord, this is a land acquisition matter where we
Why
pay.
the officers didn't turn up for me?
No, we did. On twice they didn't come. We have come all the way from the Garo Hills, all the Nokma, they have come twice, but their officers, even the lawyers, they failed to appear on 2 occasions.
That's not true, my lord. We did appear.
It is there in the record.
My lord, I also.
Mediator was there, and we have present, and the second occasion, yes,
there's a report.
they didn't come up.
My lord, the thing is that day it was raining heavily. We tried 3 to 4 times, my lord, to connect to the internet to get through the virtual call, the virtual hearing. But we couldn't, sir. We also sent a screenshot of what happened on that day.
Virtual court means, my lord, the mediation, we are supposed to be there only. So they didn't come. Officer, they are supposed to come to the office. The virtual is only for the mediator from from Joy. The mediator was appearing in the court. We are supposed to present in the.
It was virtual, my lord.
In the court, in the conference room. My client, they have come all the way twice.
To where?
Here in the conference room, in the High Court. Mediator was appearing from the.
173 people you came.
Those around 10 people they have come representing. The person who signed the affidavit, they have come. I also was there. But neither the officers.
Shillong, why didn't you appear?
My lord, I was traveling, my lord, so on the way, my lord, I tried to get in and also.
No, it's not, if the date is fixed, you should have made.
Yes, my lord. So
arrangement of some.
Yes, my lord. Even
if this is, mediation is sacrosanct in many ways. That it can be settled, especially if there are so many people involved.
Even the mediator was expressing his displeasure because he said,
That's not true, my lord, because we
he said, I have wasted my time.
No, my lord, we kept on calling saying that we could not get through the link, my lord. We also sent screenshots of what happened that day.
You can't submit while you're traveling.
No, my lord, we stopped in a place to.
You cannot do on a phone.
Their officers supposed to come to the office.
I was
to the conference.
My lord, I was only in Nongpo court, my lord, and we tried to get through with the virtual call, and it didn't happen because it was raining. I sent screenshots of what happened. I kept on clicking on the links of it, my lord.
We don't know what happened, but the fact is that it didn't appear.
Yes, officer indicates that the mediation proceedings were successful. The order of the mediator date 59/2025 indicates that the same was due to network issues on the part of the state respondents. You don't want to go mediation anymore?
No. If we can, if possible, I have no problem.
PT Sangma submits that the petitioner willing for mediation.
Petitioner is still willing, but we are. But then I don't know from the side.
Where are they from? West Garo Hills, East Garo Hills, which part? Of Garo Hills?
This is Nongar. From Nongar is South Garo Hills actually.
Nangal Bibra.
From Nangal Bibra, right? If it's South Garo Hills, you can go to. You can go to Bagmara.
For me, I don't know.
Bagmara is difficult. It'll be easier if you come to Tura.
Let it matter. Let the court decide because they didn't say any express. Yes, but they have not filed the affidavit. Let them file the affidavit first.
We're waiting, my lord, for the reports from the GHDC.
Yes.
Women is just a formal party.
Yes.
Item number 7.
Let them file the affidavit.
We'll file, my lord. We need 2 weeks time.
No, JHDC is not the party.
My lord, that is the reason what I was saying. It's not been made a party in this. And they have, my lord, we made payments to JHDC.
Lordship. Much less lordship.
You not made GHDC party?
They have not, my lord. No, we need to.
GHDC have not required to be make party.
Right. You argue.
But my lord, payments were made to GHDC.
Because land is purchased by the MECR. Why we will make a party to the GHDC?
Because my lord,
GHDC have nothing to do.
Item number 7.
Ordered, yes,
lordship.
Take it outside. Yes.
Much obliged, lordship.
In this matter, I'm seeking some accommodation. I have just received instructions, my lords, in this matter.
The 6th time now.
Yes, lordship. I apologize, my lords. The reason I checked with the officer concerned, the reason for the delay. On the first date of hearing, my learned friend had indicated that the order after the disciplinary proceedings were passed by Director of Corporate Affairs. A query was put forth by this honorable court that whether he is the competent officer or not, and whether there is any other.
When can he file by 1 week?
Also by 2 weeks because of the.
Though this is the 6th time that accommodation has been sought to file the affidavit, Mr. Pandey submits that the same was Pandey due to very compelling reasons. Yes. In the interest of justice, last opportunity of 2 weeks granted. Just after 2 weeks, yes.
Obliged.
Item number 8.
Yes.
My lord, this is a promotion matter, my lord. Due to lacking of adverse entry in ACR, he was deprived from the promotion to the rank of Naib Subedar GT.
Will dispose of.
And affidavit in opposition is.
You know, file affidavit.
I'm praying for some time, lordship, to file affidavit.
2 weeks for that time.
9.
My lord. Deep your lordship.
The respondents are yet to file the affidavit, Your Lordship, in this matter.
Your Lordship, I'm praying for a week's time, Your Lordship. I'm for respondent 5.
1 to 4, Your Lordship. I'm praying for some time, Your Lordship.
Speak louder. You are for?
1 to 4, Your Lordship.
File, you not file also. It's MPSC.
MPSC, Your Lordship.
Lordship, I'm praying for a week's time.
Any urgency?
Your Lordship,
2 weeks for the time has allowed the respondents to file their respective affidavits. Yes, absolutely.
10.
My lord, there are 3 matters, my lord. If my lord may kindly see. Writ petition number 348, 349 and 354, my lord. My grievances in 349 and 350, my lord, has been addressed, my lord. Now only 349.
Now only 348 remains. What remains 348?
Only 348, my lord.
What remains?
They have not yet paid my
security
money.
Is the amount certified?
Lordship,
This is only security money that I have deposited. My
return security money.
Lordship, if the can record grants me 1 month's time, Lordship.
You'll pay it.
That's my instructions.
So let that be recorded and the matter can be disposed of that within 1 month. They will release the money.
Adult VC number 349 and 354.
Yes, my lord.
The
Lordship, this
349 and
348, my lord, is already.
now
348 is not yet addressed, my lord.
Yes, no. Once the other ones have been addressed, we'll pass.
349 and 350. 349 and 350.
Record in 349.
350.
Mr. S. D submits that the grievances of the writ petition has since been redressed. No longer wishes to press the petition. Accordingly, the writ petition stands closed and disposed of. Have not pressed. And 350, same order. And then 348. Mr. H. Karanlang submits that if the respondents are granted 1 month's time, the credit deposit of the
we'll try to
of the writ petitioner will be returned. Stop. Next one, Mr. S. Day, to the submissions of the learned counsel has no objection. Accordingly, the respondent's number.
Lordship, I'm supposed to get a brief.
Don't have brief.
All the respondents, my
I've
lord.
just received the instructions this morning only, Lordship. Don't have a
For the respondents.
Yes, 1 to 3, my lord.
For the respondents, if the respondents are given, not he.
Security deposit and dues, my lord.
And other dues will be refunded, yes. Purpose has no objection, yes, to the suggestion made by the valid counsel for the respondent. Stop. Accordingly, it is directed that the legitimate dues of the writ petitioner, if any, such as security deposit, shall be refunded within a period of 1 month from the date of receipt of this order by the respondent.
Right.
Yes.
Hello,
As ordered above, matter stands disposed of.
Hello.
Much obliged.
13.
Lordship, in this case, we are awaiting instructions. We may have allowed some time, Your Lordship.
We have taken steps on respondent number 5.
You appear on number 5, Mr. Barsaji?
No, but he is with me, Your Lordship. 1 to 4.
How many laws are appearing? Last time G. N. Ranja, or who's appearing?
Mr. Rinja is also there.
Also in the same case.
Because there is a similar matter, Your Lordship.
Number 5?
Number 5, not yet.
No, my lord. We have just taken
They've been
steps.
served or not?
Not yet, my lord.
Actually, this case, we are challenging the maintainability, Your Lordship, because this petitioners have no locus to file the case. And there is a similar matter regarding the same subject matter, which is pending before Your Lordship.
You take down MST Yangi B prays for further time to file affidavit submits that the respondents are questioning. Someone want to focus on maintainability of the incident petition. Next paragraph also indicates that the notice been issued to 105 service reports not yet received. Just after 2 weeks for affidavit for service report.
Oblige, Your
So
Lordship.
to stop, the petitioner is also permitted to obtain status of service before the next day.
14.
Zero service on respondent 5 for the next day.
Please, Your Lordship. Lordship, notices have been sent to the respondent number 5 in this matter.
Your Lordship, I'm bearing on behalf of respondent number 5. I need 3 weeks time.
Hiram, Lordship.
I need 3 weeks time, Your Lordship, to file my affidavit.
Have you filed affidavits in other cases also? None of the cases you filed
I
affidavit.
filed, Your Lordship.
You filed? Yes. There's the order here.
Yes, Lordship. There's an interim order keeping the impugned order dated.
Or referendum.
Yes, Lordship.
What about the council?
Council won't be filing answer.
Only number 5. MS also has entered appearance behalf of respondent number 5 to the and as such notice complete. Or complete
Yes, Lordship.
Respondents. Notice is complete. The response allowed.
3 weeks time, Your Lordship.
Trying to file affidavit stop. Mr. J.K. Paryat, Vice Mr. T.V. submits that. No appeal forthcoming from the respondents number 1 to 4. In this after 2 weeks, interim orders if any to continue the next date.
Highly obliged.
Hearing 15.
May please, Your Lordship. Lordship, I pray for some more time for this matter, Lordship. The Learned Advocate General and the government are still trying to resolve the matter, Lordship. Just require some more time.
But you don't want to appear before the court, the contempt.
Lordship, I have, if...
Anyway, Mr. H. Kanalang submits that as this steps have been taken to comply with the orders of this court. The matter is up to 3 weeks.
Much obliged.
17.
Please, Your Lordship. Lordship, in this matter,
You ready?
the hearing is done, Your Lordship. Lordship, the hearing was done on 3rd of July 2025, and Your Lordship has directed the state respondent to approval the managing committee.
Where is the order?
So this is a matter where there are two connected matters. One, the petitioner in this particular item claims to be the senior most teacher, and he wants to be the headmaster of the school. He has about 2 months to retire, I think. And in the second matter, Lordship, there the petitioner claims to be the junior most teacher, but the most qualified teacher. And
so she is senior most teacher.
He is senior most,
but not qualified.
Not qualified.
Junior most teacher, but qualified.
According to him, he is senior most. According to the record, he is not. But be that as it may, in the second item, admittedly, he is the junior most, but he says that he is most qualified, so he should be the head teacher.
You are the junior most.
Now, I am the, according to the record and as per the approval of the government, I am the senior most teacher who is appointed as the in charge head teacher for the smooth functioning of the school.
Third person.
I am the third person involved.
Both for the junior most.
Yeah, I'm also there as a for the petitioner.
Yes.
Secondary petitions.
Who are you?
I am the person having a higher qualifications.
But junior most.
Junior most, but I'm having a higher qualifications.
Lordship, here
No,
the
you are the
respondent
senior
number
most.
3 has to come in decision, Your Lordship.
So
Who will be the
where the
headmaster?
order you are referring to?
So, Lordship, order is 3rd of July 2025, Your Lordship.
Now, in the meantime, there is no
1
SMC,
second.
which is why that order was passed on.
Pass, Your Lordship.
3rd of July
3rd of 2025.
2024.
5, Your Lordship.
Where's Mr. Sincon? He's appearing this matter, correct?
Mr. Sincon is appearing a lot.
Then where is he? He was here arguing the other matter. You get him?
What Lordships had indicated was that if at all they proceed with constitution of a regular SMC, thereafter the SMC can take a call as to who can be the...
No, that's what we got instructions from him.
Lordship.
He never produced a list after that.
No, Your Lordship.
This
It's always secret.
had expired somewhere in 2023, 22nd December 2023.
This is passed in 283. Okay, only 2 days have come after that.
Lordship.
expired on 22/12/23.
Lordship, yes.
And to produce the last approval.
Thereafter, there has been no SMC.
How's it running now?
It's just running at the. I am appointed as an in-charge head teacher, just to ensure the smooth functioning of the school, and that is how it is going.
Where's the Syncon? Something matters giving.
G3. G7 2025.
These two items, my lord, this the main item which has been called item number 17, my lord. This actually, this matter has been assigned to Mr. Adaya Momin. So, my lord, Mr. Singham was requested, he has appeared on this particular day when the order was passed. So, my lord, and we have been informed that the files have all with Mr. Adaya Momin. There was a difficulty today, and I was informed by my friend that there was a specific order passed. I've seen this order also, and we have tried to check from the correspondence file of Mr. Momin from the office whether he has sent letters and some instruction has come. So we have not found. But madam, the other matter is Mrs. Bhattacharjee. So she is on leave also. So we have to speak to her also. Your Lordship can have it next month. These are difficult.
Lordship, the only difficulty was that I'm going to retire next
Yes,
month.
we'll have it after 1 week.
Lordship, make sure that all the instruction comes.
Yes, Ms. Ark only submitted that the councils handling these matters, one is indisposed and the other is on leave. As such, she has no access to the records of the state respondents. In consideration thereof, this does matter after 1 week.
Obliged.
19.
Will not be asking about the earlier order.
19.
Lordship, this matter, Lordship, the instruction is that, Lordship, the government has issued the standard operating procedure to fill up all the sanction posts occupied by the ad hoc appointees, Lordship. So there will be a fresh recruitment, and also the incumbent ad hoc employees will be given the age relaxation of the upper age limit.
We'll close it.
So he can avail of that age relaxation and sit in the recruitment, Lordship.
It may be reported, Lordship, that they are.
Yes, we've seen the SOPs, other matters also.
Yes.
Mr. H. Karmi today, Mr. H. Karmi, the additional senior government advocate today submitted that the state respondents have issued SOP dated.
Is issued through the memorandum dated 25 September 2025.
SOP, a white memorandum dated
25 September 2025.
09/2025, wherein
this is cover all the ad hoc
wherein
parties.
Instructions have been laid out as to the regulation of ad hoc employees working against sanctioned posts appointed after 2007.
Up to December 2007.
Up to December 2007.
There are more than 1,500.
He submits that the claims of the petitioners therefore will be necessarily have to be in the light of the said memorandum. Next one, Mr. SDEP on the submission submits that as this is a further development, the petition will be closed at this stage.
And the respondents will be directed to
given him to
complete the process.
No, liberty will be given to him to agitate if still aggrieved.
Lordship, they have to send my name for the cabinet. And
That
all.
will be done.
I will call for an interview.
It will be follow up by the
SDEP on
department.
submissions made by the Leonard Senior Government Advocate Archival submits that the names of the petitioners therefore may be sent for consideration.
And necessary complaints from our end will.
Under the
Lordship, it will be done as per the SOP.
light of the new memorandum wherein the SOP is contained.
Yes, Lordship.
On hearing submissions of parties, accordingly, this matter is disposed of by directing the state respondents to take up the matter take up the case of petition for consideration as to eligibility for organization under the new SOP. Dated
25th September 2025.
9/2025.
If your Lordship pleases, I'll give a copy. I'll hand over a copy of this SOP.
Yes, next one. Matter according stands closed and disposed of.
Closed. Disposed. Obliged, Lordship.
20.
May I please, Your Lordship? Lordship, Senior Counsel, Sir K. Paul is on his leg. Kindly call up the matter end of the board, Your Lordship.
End of the board? We're already at the end of the board now. Yes, Mr. What's the matter about?
Lordship, that the election was held, but the results were declared. After that, the approval was stayed by the
VC.
PC Lordship.
You can argue it. Where's Mr.
November.
Hassan? Is he on the case also?
Your Lordship.
Only you.
Here, as per the
Kindly call up the matter end of the board, Your Lordship. Sir Paul will be here.
Yes. What is pictures here? We'll have it next week then. Yes, due to unless you have seen a council's matter next week.
Interim order may continue, Your Lordship.
Yes?
Interim order may continue.
Interim order?
Your
Okay,
Lordship.
interim order may continue.
Your Lordship.
21? 21 is almost a matter, but in Lordship, the matter has been adjourned again and again on the basis of...
By whom?
It's connected, Your Lordship.
You have same petitioner there.
20 and 21 are connected.
Taken next week.
Villages have been suffering, Lordship.
You bring a senior next week, otherwise you argue it.
22.
Lordship, the petitioners have filed implement application yesterday, Lordship. I've just received the application.
Who's for the petitioner?
I'm the petitioner, Lordship. Lordship will file the implement petition for respondent number 3, private respondent number 3, Your
Who is
Lordship.
the
As
new
per the last
respondent to
order.
add? Nasrina Abdin. You have any objections?
No objections.
Yes, sir. Take down Miss Case number 273 for 2025 WC number 466. There's an application for impediment of necessary parties. One Srimati Nasrina.
Yes,
Is
Srina.
it Nasrina Abdin as respondent number 3? Why you want to plead her? Who is she?
She's the one who holding the post of West Carroll district, Your Lordship.
Of?
Lordship, the post was divided as district wise, and she was the one who is holding the post of West Carroll Hills, and she is from Southwest Carroll Hills, Your Lordship. So, as per the last order,
The same objected to by the council for Mr. So-and-so. Accordingly, the applicant stands allowed, and Srimati so-and-so as the name of the Ahine stand impeded as one number 3 in the writ petition. Registry to make necessary corrections in the first title stop. And the main case, in view of the order passed and so please to take steps for issuance of notice to the Union Principal number 3 within 3 days. List after 2 weeks in the order column.
obliged, Your Lordship.
23.
By Your Lordship's last order, I was supposed to receive some instructions from the government. I have received the instructions only last evening, Your Lordship.
What are the instructions?
Instruction is that B.Ed is compulsory, Your Lordship. Because the assistant head teacher, even for an assistant head teacher to be appointed, one must have a B.Ed degree, Your Lordship.
You've shown that to him?
I just, I've not yet shown him, Your Lordship. I just have a copy, I have not been able to.
You have to place it before the board.
No, it is not required as per my law. My lord, it can.
Because the NCTE, Your Lordship, National Council of Teacher Education, that rule also, regulation also says that it is mandatory, Your Lordship, and that there are subsequent notifications from the government and the circulars, Your Lordship, which says that henceforth any appointment to be made of teachers should have the qualification, Your Lordship. Otherwise, the government will not approve.
You're relying on the Assam Department.
We are relying on that, Your Lordship.
Let's see what
This is the act only. And it is not amended, Your Lordship. And that recognition 2012, it is not applicable on diversity school. It is for the new school. Your Lordship, can you peruse that recognition of 2012?
I may be given
it is for
some
new
time,
school.
Your Lordship, so that I can make.
If Your Lordship peruse the
copies.
whole act, it is that clause.
What are we to do today? Matters has been lingering on.
Yes, Your Lordship.
Yes. Okay, we'll give you one more opportunity. MSP Yangi B, then at EAG submits a she's just received an instruction that B.Ed is a necessary requirement. Stop the same contested by Mr. S. Islam, who submits that the said requirement is not
Is
applicable
not
to
necessary for deficit schools.
To deficit schools. Stop. Whereas that may, in the interest of justice, they are permitted to bring the rival contentions or instructions will be affidavit for next day. Just bring it to the court. Yes. List after 2 weeks. Yes.
26.
Matters just lingered on unnecessarily for.
And he is going to be retired then.
Yes, where were we last time?
On the issue of maintainability, my lord.
Where are you?
My lord, I'll just keep going. Yes, my lord.
Can't even see him also. Yes.
Am I audible, my lord? Yes, my lord. I'll just change.
Change what?
Change the position, of course, because there's a reflection of light. That's why, my lord.
Yes.
My lord, this matter, my
He's
lord,
saying I just change is a very loaded word. Yes. Yes. Yes.
My lord, in this matter, we are in the Dorbar, we are discussing, my lord, and how to go about solving, because how do we rectify whatever past mistakes has been done, or how do we issue a notice? And we are in consultation with the CE, my lord. So what I would like to pray today is, my lord, kindly give us a week or 2 weeks time, my lord. We will discuss something, my lord. We may come up with something, my lord.
My lord, if it's adverse to me, my lord, then the entire proceeding itself might become.
It's before the court, Mr. Vessel. Why you're submitting?
My lord, they are
free. If it leads to a resolution, well and good.
Yes, lordship.
My lord.
The court will pass necessary orders. Nothing can be undone.
Yes, my lord.
Yes, Mr. Euban submits that
yes.
the matters being actively examined by the respondents in consultation with the CM to arrive at a viable solution. Yes, he therefore prays that some time be allowed. How much time?
2 weeks, lordship. 2 weeks, my lord. Yes.
Yes, accordingly, 2 weeks granted. At least after 2 weeks. Yes. Next line is after 2 weeks. Right, how will you compensate him? Yes.
My lord, we'll have to work out something, my lord.
Yes.